Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to get to talk about California again, and I so frequently love talking about California. Why? Well, because California is usually in the court system getting their ass handed to them, and today is no different because, yes, California has once again taken a big one on the chin. And I got to be honest with you, if Governor Newsom and Rob Bonta were boxers, they would both have to stop their career at this point because they would both be punch drunk. They have taken another huge loss today. It was about another crazy, absolutely unconstitutional law, but this time it's unconstitutional on multiple grounds. We'll explain in just a moment. So today, let's spend a few minutes and let's talk about how California just got smoked on another gun law. Okay, hey, before we get going too far down the road, we're talking about California, which means we always give a shout out to our first ever California subscriber. That, of course, is Philip P. Philip P was actually kind enough to send me the opinion, which I was able to get through before shooting this video. He was our first ever subscriber down there. He's been spreading the gospel of Washington gun law in the Golden State since that time. Philip P, this one's for you. The case we are talking about today is B&L Productions v. Newsom. It is a case that is brought to us by our good friends at the Second Amendment Foundation. We will link them up down below. If you want to join and show them some love, please do so. This is a challenge. California, you may recall these bills, but you got so many kicking around. But this was to Senate Bill 264 as well as Senate Bill 915. Now, you have so many pieces of anti-gun legislation flying around in your state on a daily basis, you probably cannot keep track of it. These were the bills that were going to end gun shows in the state of California forever, okay? And that was their stated purpose. And in fact, we'll talk about in a moment how their stated purpose really kind of turned around to come back and bite them here. Now, I recently just did a video where I said that the dumbest gun control laws come from the state of New York, the most evil and nefarious gun control laws come from the state of Illinois, and absolutely the most unconstitutional gun laws come from the state of California. Well, I got to admit it, California, you have absolutely outdone yourself this time because we've only really found a couple of gun laws that had been struck down on multiple, that is 2 constitutional grounds. But California, congratulations, this law has been struck down on 3 separate grounds. That's right, 3 separate grounds. Now, it was struck down on Second Amendment grounds. That should come as a shock to nobody. But it was also struck down on First Amendment grounds as well as equal protection grounds under the 14th Amendment. Now, I shouldn't actually be using the term struck down because the ruling actually comes on a motion for a temporary injunction by the plaintiffs here, and there are multiple plaintiffs here. And the court has, in fact, granted that injunction and denied a stay of that injunction. We've been seeing that lately, like, yes, I'm going to enjoy the law, but I'm going to stay it for 10 days so you guys can appeal. This one does not have a stay. This law is enjoined as of this moment. Now, obviously, the state of California will appeal, they'll go crying to the higher court, and there'll be plenty of other videos to do on this. But the reason that winning on a temporary injunction is so important, as we recall, is that there is a 2-part test, one of which is you have to show that there is irreparable harm, and the name plaintiff here actually puts on gun shows, so you can imagine what a huge financial impact and what irreparable harm that would create. The second and equally important, and oftentimes even more important factor, is that you are likely to prevail on the merits. So the court here has ruled that not only is B&L Productions likely to suffer irreparable harm, which I have zero doubt of, but that all of the plaintiffs here are likely to prevail on the merits. Now, why we so frequently focus on why laws are unconstitutional from a Second Amendment ground, we are going to actually get to do a cool little detour today and talk about why this law was actually struck down on First Amendment grounds. You guys geek out on the Second Amendment enough. You know why it was struck down. It's obvious that the activity is covered by the text of the Second Amendment. Bruin says if it's covered by that, then there, of course, must be a historical analog. With an absence of a historical analog supporting a similar type of restriction, it is per se unconstitutional. That's exactly how the court ruled. But what I want to focus on today is what the state of California did here to restrict commercial speech, which is in fact a violation of the First Amendment. I mentioned earlier in the video that one of the reasons that the court had a big beef with this statute is what its purpose was. because those who were proposing it, that is State Senator Dave Min, well, he was very, very vocal. And as he was chumming his base of voters, he got very braggadocious about what the purpose of this bill was. In fact, he was quoted as saying, "In my first 100 days in office, I promise to author legislation for a ban on these gun shows at the OC Fair and Events Center once and for all." And then in comments about Senate Bill 264, the state senator was quoted as saying, "SB 264 will ensure that the state is not profiting from the sale of firearms and ammunition on state property or facilitating gun shows that would undermine California's strong firearms regulations." Well, you see, Senator, those statements have in fact come back to bite you because, as the court then pointed out, plaintiffs move for a preliminary injunction based upon several theories under the First Amendment. First, plaintiffs assert that California's ban on the sale of firearms at state-owned fairgrounds is a thinly veiled pretextual attack on the gun shows themselves and that the laws are an unconstitutional censorship of content and viewpoints. And you see here what the state tried to say is, no, we're regulating the sale of firearms. But the court was quick to point out, no, you're actually only regulating the commercial speech necessary to complete those transactions because there is no gun that is ever sold at a California gun show. No, remember, they all have to go through FFLs. All the paperwork has to be filled out. And there is a statutory waiting period. So the transaction never ever occurs at a gun show. Only speech related to that transaction can occur there. And therefore, the court found, for a sale to occur, the participants must engage in commercial speech in which the seller informs the buyer about its product, the participants engage in a negotiation, and they set a price and other terms for the exchange. Because commercial speech is usually defined as speech that does no more than propose a commercial transaction, legislation that restricts sales also restricts commercial speech. And that is a huge problem for this piece of legislation. Now, unlike on our Second Amendment rights, where we use a text and history analysis, free speech cases in the state of California are still subject to an intermediate scrutiny test that is a balancing of interest, and they use what's called the Central Hudson test in determining what is permissible restrictions on free speech. However, even with that watered down test, the court has found that, hey, this does not pass constitutional muster. As the court has ruled, even if the court were to conclude that banning lawful firearm sales at the Orange County Fairgrounds directly advances California's interest in stopping illegal weapons sales, the regulation would still be more extensive than is necessary to serve that interest. California's interest in stopping crimes committed with illegal weapons, as important as it is, cannot justify prohibiting the complete sale of lawful firearms at gun shows, especially when those same firearms are available for purchase at regular gun stores, and, in fact, the firearms purchased at gun shows must be retrieved at brick-and-mortar gun stores. And ultimately, one of the things that the court is instructed to look at when judging the constitutionality of restrictions that are placed upon commercial speech is the restriction viewpoint neutral? That is, does it actually have a purpose other than to suppress a particular viewpoint? Now, this is the state of California, and it deals with guns. So we know the answer. And then, of course, let us also remember that Senator Min was very vociferous, very braggadocious, if you would, about why he wanted to pass this law. Well, that was not lost upon the court because they have ruled, in addition to being reasonable, the state's exclusion of speech from a limited public forum must be viewpoint neutral. Discrimination against speech because of its message is presumed to be unconstitutional. Although a regulation may be deemed neutral, even if it has an incidental effect on some speakers or messages but not others, viewpoint discrimination occurs when the government prohibits speech by particular speakers, thereby suppressing a particular view about a subject. And of course, that is exactly what the state of California did here. So big problems for this little piece of legislation, right? Correct. The court then went on to rule. Here the court finds sufficient evidence that SB 264 and SB 915 have a viewpoint discriminatory purpose. Legislative history shows that the goal of the two statutes is to end gun shows in California. And while the opinions and statements of legislators are not dispositive of viewpoint discrimination, those statements are circumstantial evidence that the statutes disfavor the lawful commercial speech of firearm vendors. That's right, Senator Mann. Your words helped get this piece of legislation too. Now, in addition to that, there was, as we mentioned earlier, the typical 2A challenges, which were successful under the Bruin analysis. And then there was also a successful equal protection challenge that was granted as well, which is a deprivation of commercial speech, First Amendment rights under the color of state law, which was, of course, then guaranteed through the 14th Amendment. So again, congratulations, California. You have successfully passed a piece of legislation which has been struck down now, not on one, not on two, but three separate constitutional grounds, only in the state of California. Listen, the case once again is B&L Productions v. Newsom. We'll link up the ruling down below so you can geek out on it for yourself. In the meantime, if you've got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is also right down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.